So there have been a number of new risks, evolving risks, typologies, and to try and explain this, the best thing is probably to go to an example. And I guess one of the most critical examples, and an example that affects Asia significantly, is trafficking. So human trafficking, anti-slavery. And of course, all of this is done as a business. I mean, it's a very, very profitable business. The criminals will be making billions of dollars of profit every year. Yeah, I mean, obviously the costs are minimal. And all this money gets laundered through banks. It has to. It gets through the financial system. And that's what the criminals are targeting. But it looks different. It looks different to, types of money laundering, other types of money laundering. The amounts of money could be very small, potentially, right? And you also need to look at where perhaps bank accounts are being misused. So criminals might set up bank accounts for trafficked people, and then operate those bank accounts themselves. And so obviously there are different typologies that this creates. And financial institutions, insurance companies and the like need to be aware of these evolving typologies. Otherwise they're going to put themselves in risk.
When we talk about data privacy and cybersecurity, in this side of the world, it's considered as quite silo. We're seeing CIO, CISO, and even head of cybersecurity regard cybersecurity program is very much a siloed program where they do not actually align with the wider global governance, risk and compliance program within the organization. And we've seen data protection officers in certain organizations where most of the activities are predominantly very legal. It's very much a box-ticking exercise rather than socializing and stress testing the environment and having the cybersecurity guys to work together and really bring this program to the next wider level of the compliance within the organization environment. And because of these teams, data privacy and cybersecurity is evolving in Asia, and we're seeing jurisdictions like China, Singapore, Southeast Asia, even Japan, South Korea have actually taken this as a top priority, and lots of education to be done as well to the wider stakeholders and in the market.
Some of the strongest data privacy regulation there is out there, and that is at the moment GDPR guidelines and the CCPA, the California guidelines. So if we were to use those as a benchmark and for the company to itself adopt a lot of these practices, I think the company would be in a safe place. And it would also not be trying to navigate across various jurisdictions that's doing business, because the trend is also for regulators in Asia to be cherry picking, using that word again, and looking and following certain details across the GDPR and CCPA, and using that to set the standards for how they will guidelines and how they would enforce.
I think there's going to be continued economic uncertainty into 2020, and what we're going to see as a result of that is a number of fraud and corruption risks increasing. Firstly, management and employee fraud is likely to increase. In hard times, there's always a potential for management and for employees to be looking for other ways of extracting value from the company and making more money than they've made previously. So there might be employee expense fraud, there might be setting up of outside suppliers, third-party suppliers, where they can extract value from the company that way as well. So there's going to be those type of frauds that take place.
Rule number one, and I didn't say it today, but I meant to, is don't talk to the government. Call your lawyer, at least with respect to the U.S., and I think, Leon, you would say the same thing here. Under U.S. practice, anything that a U.S. lawyer brings to bear on an investigation, we can cloak in privilege, which is extremely important because, and it may not work in some other jurisdictions, but at least for the purposes of a U.S. Investigation, I do not want the SEC or the Department of Justice to have the ability to get behind my thinking, my work product. If I direct MWE discovery, or on the China side to have the Chinese information pulled and reviewed, I can keep that privileged. So even a subpoena from the government is not going to require me to produce that information. And that's extremely important on the front end when you're going through an investigation, to have that level of confidentiality for a number of reasons. And one of them is you want your client to open up to you. You want to be able to get the full story. And if they're concerned that things are going to be turned over to the government as part of the process of lawyers interviewing them, you're not going to get the full story. And so it impacts the viability of the investigation, and ultimately it can impact the ability of the company to either settle a case with no charges or try to mitigate the risk to the extent possible. So I want to encourage full disclosure.
I understand that the Chinese government and the law, they have their own requirements about the data cross-border transferring. And on top of that, you know that in certain sensitive and strategic industries, there are this kind of China criminal level law restricting or even forbidding you provide the data directly out. I'm not just talking about the state secrets. I'm not just talking about the ICGAL. This is a new law come out just as of a part of a response against the China Initiative plan from the US. So for that, it's very straightforward that for Chinese companies that you cannot provide the assistance to the foreign criminal judicial procedure without going through the central government central level of the procedure. If you do that, you are in criminal level.
At the start, and what discovery means, it's not just your document review. That's actually the middle of the process. Ultimately, like discovery, it starts with information governance. So the way your end clients, the way the people you deal with are managing and storing their data, the rules that they have around maintaining information. Now, there's not too much we can do with that, except for, when you're asking for information from your client, when you're coming up to a discovery stage, my number one rule is always ask for electronic information in an electronic format. Now that sounds pretty simple, right? But I have lawyers coming to me with folders of printed out emails, and they're wanting to understand the quickest way to get through those folders for their document review. The quickest way is to not print the emails.
I don't think we see any fraud investigations that we conduct that doesn't have an electronic element to it. More and more so, there is data out there that is combined with the forensic accounting piece. So combining the two, definitely, with increasing data, increasing volumes of data, increasing financial records that are in electronic format. We see that quite often the case in China, in terms of individuals having their own personal machine or personal device, but having company data on it. So firstly, within China, we would always advise and work through external counsel to seek that advice, firstly. If it is a personal device, then we would ask the custodian whether we can obtain their consent to access that data, which is corporate data. Again, we must obtain that consent. We would not, without getting that consent, access that data. If we do have that consent though, that does open up a lot of opportunities in terms of the data that we would be able to capture. There is obviously the personal data side, which we obviously must adhere to, data privacy rules against that. Often we're just focusing on the business related data that would pertain to an investigation. I think it's very important to recognize the fact that data, even though it resides in China, must be disclosed for cross-border matters. So for us, having that data, having a team on site within China, having a data center within China, allowing external counsel and local China counsel to review for state secrets. Once that is cleared, then we will work with external counsel to transfer that data out. where the jurisdiction is for that external electronic disclosure.
When we talk about data, data actually flows globally. For example, from the US to China, China to the rest of the world. So if there's a lack of control within the organization environment, so this is where the organization resilience can be potentially intruded, can potentially hacked.